What's up? Welcome to Part 3 of Crash Course, AP American Government Edition. Let's start with some foundational documents. The Declaration of Independence was a document that was proclaiming from the Second Continental Congress on July 4, 1776, to Great Britain to declare independence. Thomas Jefferson and the 13 colonies wanted to assert their Enlightenment ideals, such as life, liberty, and the pursuit of happiness. The Articles of Confederation was a weak constitution that governed America during the Revolutionary War. It was America's first quote-unquote constitution, but it failed because it promoted a weak central government. Congress couldn't tax or regulate interstate commerce, and there was no national militia nor a strong executive or judiciary branch. The Constitution of the United States was signed in 1787, and it was ratified by the required 9 states by 1788. And it was drafted at the Constitutional Convention in Philadelphia in 1787. It promoted a preamble and 7 different articles that outlined this new nation. It also created a stronger federal government, which the Articles of Confederation did not do. It also included a Bill of Rights that constitutes the first 10 amendments, and it also protects individual rights and freedoms. Federalist No. 10 was an essay composed by James Madison which argues that liberty is safest in a large republic because of the many interests, what we know as factions, when they exist. It promotes a diversity of factions to work against each other, making tyrannies impossible. Of course, we don't really see this anymore because there are some very strong and dominant interest groups today. Brutus No. was a work by a prominent anti-federalist. Most people believe it was Robert Yates, and he argued that the new federal government would be too powerful, so he didn't like the new Constitution. Particularly, he didn't like clauses like the Necessary and Proper Clause, also known as the Elastic Clause, and the Supremacy Clause. In addition, he also didn't like Congress's power to tax and raise a standing army. He was a big supporter of states' rights. In Federalist 51, the author argues for a separation of powers within the national government, and he says that this is the best way to prevent the concentration of powers into the hands of one person or a single elite group. So the Constitution, through its different articles, clearly outlines this. Federalist 70. Here, Hamilton talks about the necessity of a single president rather than an executive committee, as some people wanted. This president is also known as the energetic executive, and he or she asserts the power of the presidency. This person could act with energy, efficiency, and secrecy that a committee of leaders simply could not do. In Federalist 78, which was also written by Hamilton, he talks about the federal judiciary. The judiciary must depend on the other 2 branches to uphold its decisions, and this is a work of checks and balances as it prevents Congress or even the president from becoming too powerful. Congress was already really powerful at this time since they dominated from the Articles of Confederation days. In the letter from a Birmingham jail, this was a letter written by Martin Luther King Jr. after he had been arrested when he took part in a nonviolent march against segregation in Alabama, and it defended the work of nonviolent action at a time when groups like the Black Panthers wanted equality through militant action. In Marbury versus Madison, 1803, so now we're going to Supreme Court cases, this established judicial review, and this was the case of the Midnight Justices, where John Adams decided to appoint judges since he was leaving office to keep his party, the Federalists, in power. And John Marshall, the Chief Justice, asserted the power of the Supreme Court by ruling this was not allowed, even though he was a Federalist as well. In McCulloch v. Maryland, 1819, the Supreme Court upheld the power of the national government. It stated the Constitution is the law of the land through the Supremacy Clause, and that Maryland couldn't tax the federal government. The court also used the Elastic Clause, known as the Necessary and Proper Clause, to state Congress had broad powers to tax others. In Schenck v. the United States in 1919, speech was deemed to be able to be punished if it creates a clear and present danger. So Schenck was arrested for violating the 1917 Espionage Act by distributing leaflets to disobey the draft. Schenck thought it was a violation of his First Amendment rights, but the court decided it wasn't, since it was Congress's wartime authority to hold a draft. And it was a test of illegal acts like yelling fire in a theater. Free speech is only protected in certain times, places, and manners. In Brown versus Board of Education of Topeka in 1954, this ruling ruled that the separation of races in public schools is unconstitutional, and it reversed the Plessy versus Ferguson decision that came decades before. Linda Brown was allowed to go to a better school as a result that was also closer to her house, and this event started to end segregation in the United States. Baker versus Carr in 1961, this was a court-enforced redistricting based on the principle of one person, one vote, and it occurred in Tennessee where redistricting was drawn unfairly, making urban votes unequal to the rural votes. And this decision allowed the Supreme Court of the United States to regulate congressional apportionment, which usually happens after a census is held. In Engel versus Vitale in 1962, this case prohibited state-sponsored recitation of prayer in public schools by the First Amendment's Establishment Clause and the 14th Amendment's Due Process Clause. A New York school district had a non-denominational prayer at the beginning of the day, and some people didn't like it, so they sued. It became an instance of the separation of church and state, as the court found that New York was endorsing religion by holding this type of prayer. In Gideon versus Wainwright, 1963, this case extends to the defendant the right of counsel in all state and federal criminal trials, regardless of their ability to pay. So this is in accordance with the Sixth Amendment. Gideon was arrested for burglary in Florida and sent to the state court, but was too poor to afford a lawyer. This ruling decided to assert the Sixth Amendment and also state that the court must appoint you a lawyer, even in state courts. In Tinker versus Des Moines Independent Community School District, 1969, this was a historic Supreme Court ruling from 1969 that cemented students' rights to free speech in public schools. The Tinker siblings wanted to wear black armbands to school to protest the Vietnam War, and then they were expelled. Armbands were determined to be pure speech by the court and not disrupting the school's operation, so it was allowed. In New York Times Company versus United States in 1971, Nixon didn't want some Vietnam War info to be leaked because he considered it classified and called on prior restraint to prevent the Department of Defense papers from leaking. However, the court ruled against this and supported the freedom of the press, even in cases involving national security, like this one. In Wisconsin versus Yoder, 1972, the court ruled that Wisconsin could not require Amish parents to send their children to public school beyond the 8th grade. This was due to the First Amendment's Free Exercise Clause. Forcing children to go to school past 8th grade would have been a violation of the Amish's ability to freely exercise their religion and their long-held religious beliefs. Roe versus Wade in 1973. This stated that abortion rights fall within the privacy implied in the 14th Amendment, which also guaranteed a woman's right to abortion in the United States. Shaw versus Reno, 1993. This occurred in North Carolina. There were two weirdly primarily African American districts, and they were drawn this way. However, this court decision said that racial gerrymandering was no longer allowed, and that race cannot be the sole or predominant factor in redrawing legislative boundaries. Majority and minority districts were no longer allowed, like this, such as the 12th District, since it violated the 14th Amendment Equal Protection Clause. Specifically in North Carolina, this was a stretch along I-85 that had a primarily African American community, and so if they drew a district this way, they could sort of dilute the votes of the Democrats in this instance. In United States versus Lopez, 1995, Lopez brought a gun to school in Texas, and that was not allowed, since the Guns-Free School Zones Act had just passed. Congress passed it using the Commerce Clause of the Constitution, but the Supreme Court decided this was an overuse of the clause and made Congress rewrite the law. So, when Congress was rewriting it, they decided to use the Necessary and Proper Clause in order to gain power and regulate guns near state-operated schools. In McDonald versus Chicago, 2010, the Second Amendment right to keep and bear arms for self-defense was applied. Mr. McDonald wanted to buy a gun for protection in Chicago, but a recent ordinance had prohibited residents in his area from doing so. So with this ruling, he was able to get his gun rights back. In Citizens United versus Federal Election Commission 2010, this ruling effectively freed labor unions and corporations who were previously limited in what they could do politically to spend money on electioneering communications and to directly advocate for the election or defeat of candidates, so they could now personally support a candidate in an election. This peeled back a lot of the regulations on campaign finance and also allowed for the formation of super PACs, which still dominate to this day. So this has been Foundational Documents and Court Cases in American Government. I'll link a few good websites where you can read up more about court cases and documents below. Thanks so much for watching this entire series on AP Government. You can find the full AP playlist here. Please make sure to subscribe if you haven't already, and like, comment, and share these videos with your friends. Thanks so much for watching, and hope to see you in another one.